insurance and you think you're in compliance and you have an insurance program that at least checks all the boxes in terms of what an AIA contract requires, you're wrong. Because there is no AIA requirement anymore. Instead, what you have is all of the insurance provisions have been exported to an exhibit, which is a fill-in-the-blank exhibit, allowing the owners to pick and choose and decide what they want in terms of different levels of coverage, limits of liability, et cetera, or limits of coverage. So that's something you really need to look at, and I don't say this just because of where we are today, but even as a construction lawyer who I think understands construction insurance more than most lawyers, anytime I look at a contract, I say you also need to get your insurance agent to look at this to make sure you have what the contract requires, and if you don't, to figure out what it would cost you to supplement your coverage so you can build that into your price. You're not expecting to have to provide insurance at your own expense, I wouldn't think. The certain aspects of the AIA documents, the A201 general conditions, have become less contractor friendly. A lot of contractors felt they weren't very contractor friendly to begin with. They're even less contractor friendly in certain areas, such as on the termination for convenience. One of the oddities of the AIA document, again, ever since they first adopted, there was no termination for convenience clause in the AIA contract when I first became a construction lawyer in 1981, and we were working under the 77 edition of the A201. And I think 87, they adopted a termination for convenience clause, giving the upstream party the right to terminate the contract even though you've done nothing wrong. But it came with a very attractive parting gift, because the AIA document, unlike any other contract I've ever seen, said that if they exercised that right, you got paid the profit you would have earned on the unperformed work. So it's kind of a good thing. And the only reason I can figure that was ever in there was it was a compromise to sell the termination for convenience clause by making it contractor or subcontractor friendly. Well, that's now gone. They've taken away that, and they do have a fill in the blank that allows the parties to negotiate sort of a termination bonus, if you will, to compensate the contractor for the fact that you're not going to be able to redeploy all your people and your resources immediately. There is a cost associated with being terminated when you have done nothing wrong to prompt that termination. That's really all I'm going to say this morning about it. Again, in your materials, if you're called upon to look at a AIA contract and it's your first time looking at the 2017 edition of the A201 or any of these other forms, I've got sort of highlights. One of our lawyers I think he prepares all of the construction contracts for SunTrust Bank, and they use a modified AIA document. And he actually put together this information of some of the things he sees most significant in terms of changes in the AIA. So I share that with you, but we're not going to, in the interest of time, we're not going to talk about it. I will hit this, tell you that if you really want to deeper dive into this subject, there is information available online. AIA has a website. You can actually go see a redlined comparison of the 2017 edition to the prior, the 07 edition on their website. I'm assuming that's still up. And the comparison, not the website. AIA hasn't closed or anything. By the way, and I will take this one last dig at architects, if you're curious why they are so protective and such proponents of their contract forms, it might give you a little insight to know that the American Institute of Architects' largest source of revenue is the sale of their contract forms. They make more off of selling their contract forms than they make from receiving the dues of their members. So it is something they feel very protective of. They definitely have a very strong vested interest in promoting the use of those forms. I think a lot of the rank and file architect members of the AIA don't like certain aspects of the AIA documents, but it is a very important thing to their association, and which helps explain a little bit why you see them so much and why architects are such strong advocates for the use of the forms. They're still the 800-pound gorilla in the industry. If you see a standard industry form, odds are it's going to be an AIA form still. They've been around for over 100 years. I find, I don't know what y'all find, but a lot of times they get used just because of familiarity. A lot of times I find that lenders want to see the owner use AIA forms because it's what they're familiar with. And if you show them something else, if you show them consensus docs, for example, which I'll talk about briefly, they say, hey, that's a pretty good document. They've never looked at it, never seen it. They just know AIA. Consensus docs is sort of the consensus docs is sort of the newcomer, new kid in town that is an alternative family of contract documents that was created as an alternative to AIA. They've only been around since 2007, October of 2007. So they're less than 12 years old. They have gained some traction. They're being used by a number of private and public owners. A lot of my general contractor clients use a modified consensus docs form for their subcontract as opposed to a custom-made contract that they used to use. I think the increased market activity where subs can be a little more selective about what jobs they take on has put more of a premium on a fair and balanced contract. And I would suggest to you that's part of the reason you're seeing consensus docs supplant custom contracts, which are almost always extremely one-sided. So if you're not familiar with them, you may want to get familiar with them. You know, lawyer disclaimer, and I may have mentioned this last time, I think it may be in my bios materials, but I am a past chair of the committee that drafts consensus docs. So I am a little partial, but I don't get take any percentage of sales. So I don't have any economic interest in the sale of the forms. I just think they're good forms and a good alternative to AIA. Even if you just want to look at them, if you're not happy about something in a contract that you're looking at, you think it's one-sided, and you're trying to look for something to propose as an alternative to that, look at how consensus docs addresses that issue and consider proposing that as an alternative. Okay. I'm going backwards again. Okay, consensus docs. A lot of people think consensus docs and AGC are sort of synonymous. I do a lot with AGC, as Doug mentioned in my intro, but for the subs in the group, I'll also tell you that I serve as general counsel for the Georgia Mechanical Contractors. I'm active in the Atlanta Electrical Contractors Association. So I represent subs, generals, and owners, but I have done a lot throughout my career with AGC. AGC and consensus docs are closely related, but not synonymous. AGC provided the impetus to start consensus docs because AGC for many years had their own forms, and they felt like they were sort of beating their head against the wall trying to get people to use them, because you saw that great big AGC logo on the cover, and you assumed it was really biased in favor of the general contractor, and it became a real impediment. So not trying to make AGC sound noble, but they weren't looking at it as a way to augment revenues. They were looking at it as a way to try to develop a contract that would be a better option for the industry. So what they ultimately did was throw in the towel on the AGC forms. There are no longer any AGC forms unless you have a bootleg. You typed in, create your own Word document off of one of the old AGC forms. They don't exist anymore. AGC went into a coalition, if you will, with other trade associations and came up with Consensus Docs. And it's really instructive, I think, to look at who all's in part of that, because you've got not only AGC, but you've got AGC's primary competitor, if you will, ABC, is also part of Consensus Docs. You've got owner groups such as COA, CURT, NASFA, which is a federal group, and then you've got all these specialty and subcontractor trades, electrical, mechanical, sheet metal. You've got the surety bond producers, and a host of others. You don't have AIA in there. There actually is an AIA, but it's the American Insurance Association, not the American Institute of Architects. AIA, the other AIA, was invited to participate and declined. But you have a good representation of the industry. And there were 20 of them to begin with in 2007. As of today, there are 40 organizations that are part of Consensus Docs. My clients have found it easy to sell an opposing party, and I say opposing, somebody they're negotiating a contract with. Hopefully it never becomes adversarial. But they found it easy to sell them on it when you say, well, your own organization is part of the group that created it. And they can say that to an owner, they can say that to a subcontractor, they can say that to a general contractor, they can say it to a surety bond producer. So I think that makes it a little easier to sell them. You've got, so anyway, enough about that. I've said enough. I don't want this to sound like an infomercial, but I'm a big believer in them. I think you ought to look at them. Their change, those forms are also continuing to be revised and evolved, but at a little in smaller increments. One thing Consensus Docs chose to do to differentiate themselves from AIA, instead of being on this 10-year cycle that AIA has, that we're going to revise our forms every 10 years, in years ending in a 7, which is what they do. Consensus Docs says we'll revise the forms anytime we think there's a need in the industry to modify the forms. So it has been a more gradual evolution in order to try to stay pace. And as Doug mentioned in the intro, we certainly have seen a lot of change and innovation in the industry in the last few years. If you wait 10 years, think about what has changed in your businesses in the last 10 years and ask, is that frequently enough to be looking at the way you contract for your work? There's all kinds of interesting studies and statistics and presentations on the rate of change within the world, and I think particularly the construction industry. I mean, when I start talking to our young attorneys about how things were when I started practicing law, that there was no, fax technology existed, but nobody used it. There was no such thing as Federal Express. There was no such thing as the internet. If a client called me with an emergency, I'd say, copy the contract, mail it to me, and I'll get back to you in a week. Now they send me an email and expect me to be at my desk to respond instantaneously. So the world has changed, and the rate of change continues to increase. Those are, if you are familiar with, this wouldn't mean a lot if you're not familiar with consensus docs, but in 2017 there were also some more subtle changes in the consensus docs forms, also involving, some of them also involving insurance, nothing as radical as what you see in the AIA, but some subtle changes. And they too have a website, not surprisingly. And if you want to know more about consensus docs, if you want to see what's changed, if you are using them and you want to look at the changes. One criticism, in the interest of full disclosure and fair play, one criticism I get of consensus docs is, well, they change too often. It's hard to keep track of what has changed. I mean, they kind of like the AIA only change, you know what the contract says for at least 10 years. So if, you know, and that is a little bit of a challenge, staying abreast of them. You almost have to reread it every time, but they do, at the urging of myself and others, they have tried to make it easier for people to identify what has changed, including making red line comparisons available on their website. Now here's where I want to take, okay, some of that we talked about last time. Hopefully that wasn't a regurgitation of anything we talked about last time. Here's where I want to take a little deeper dive into some of the subjects. And this is, now we're going to the graduate level course on construction contracts and legal issues. And that's your reward for being here today. We'll get into some brain teasers. I mentioned at the outset today, and I mentioned last time, how important your contract, your project delivery system is, or your contract structure is in determining your rights, responsibilities, risks, and rewards. I need to now go a little deeper in that by pointing out what is an even more subtle point, is that one thing that has changed in the industry, I would say especially in the last 10 years or so, is that even within a given project delivery system, the lines are sort of moving and have become what I refer to as blurred lines. I would suggest to you that you can no longer look at the title of a party or a description of their role on the project and ascertain from that what their roles, risks, and responsibilities and rights are. You've got to dig a little deeper. You've got to look at the language of the contract, and I'm going to give you an example of that. But, you know, construction manager is a term that we may all think we know what we mean, particularly when we, you know, narrow it a little more and say CM at risk, construction manager at risk. Masonry contractor may be a term we think we know what a masonry subcontractor or an electrical subcontractor or a mechanical subcontractor does. But I would suggest to you that until you look at the contracts, you don't really know what all that entails, because we're seeing the, you know, it's like a game of chess where the pieces are kind of moving around the board, and you could be called an electrical subcontractor. You could have an insurance program that has served you well for generations as an electrical subcontractor. And lo and behold, on this project, you also have some design responsibility. It may be, if it's design build work, then yeah, you kind of understand I'm a designer here too. But what if it's not design? What if it's design assist, so that you're helping augment the design that was done by the electrical engineer? You're fleshing out the details. Or what if the project is using BIM, building information modeling? There's an electronic three-dimensional model, three or more dimensional model of the project, and the trade contractors are contributing to that model by getting more granular in the design than the basic framework that the design team provided. Are you now just a subcontractor? Are you now a designer? Or what if, let's make it even more subtle. What if all you're doing is hiring somebody to do the design and reviewing what they did, or maybe even reviewing the design somebody else did? You need to now be thinking about buying professional liability insurance because you are now a designer. Those are the kinds of issues that you need to think about. I mean, let's face it, we live in an age of specialization. If I had stood in front of an august body like this 100 years ago and said I'm a construction lawyer, I probably would have gotten a lot of blank looks, like, how can you make a living just dealing with construction? I mean, a lawyer was a lawyer, and you hung up your shingle and you dealt with whatever came in the door. Now we tend to specialize. I tell people that my general practice physician now, best I can tell, he's just a traffic cop. I mean, he just tells me, you go see this person for that, and you go see that person for this, and it's kind of like, and give me your $60 copay. It's kind of like, so you're just kind of the traffic cop, right? And I try not to say that out loud, but it's the age of specialization. Who designed this building? Who designs the building that we use today? Is it the architect? I mean, they might come up with the, appearance, the aesthetics they're looking for, the themes. They've got consultants that design the guts of the building. Who designs things like sprinkler systems? The design team? No, the sprinkler subcontractor probably does most of the design of the sprinkler. A lot of things are now just schematic, and you figure out how it's going to all go together and how to make it work. So anyway, it's an age of specialization. It's an age of changing roles. Technology and innovation, while great things, please don't misconstrue what I'm saying as being anti-change, anti-technology, anti-improvement. But it is a cautionary tale that you need to think about the baggage that comes with that. That technology is a good thing, but you need to kind of think through, how does that change my role? And that's kind of where I want to go now. How do new tools, new techniques, new technology change the things you need to be thinking about from a legal and contractual point of view? As I say, I kind of refer to this as blurred lines. I mean, I showed you when I was here before some really neatly, neat squares and lines connecting them, defining the role of the architect and the general contractor or CM and the specialty contractors. Well, it ain't that way anymore. They're blurred lines in terms of what people's responsibilities are. And there's an article that I wrote that was in Engineering News Record about that subject in the written materials. I think there is also, I hope you're seeing, as I am seeing, at least in some markets, some segments of the country, greater collaboration. I think, for many years, the contractor was kind of kept out of the design process. And it's kind of like, you speak when spoken to. We'll call you when we need you. Let us creative people figure out what the building's going to look like, and then we'll tell you when we need somebody to come put it together, put the finishing touches on what we've drawn. Well, it isn't that way so much anymore, or at least not totally. There's greater collaboration. I think owners have realized there is value to getting contractor and specialty contractor and even some of the support services like lawyers and insurance people and bonding people involved earlier in the process. But with that greater collaboration comes greater risk. And when you have more people that are putting stuff in the stew, it gets a little bit harder to segregate out responsibility if, God forbid, something goes wrong. And again, please don't misconstrue this as my saying, well, you shouldn't do that. The best thing to do is just sit on your hands and stay on the sideline so you don't take on any liability. I think sometimes the best way to address risk is head on. But realize that there are some implications of that as you go into it. Speaking about AGC for a moment, this is going back quite a ways, but back, gosh, maybe 20 years ago, AGC was having their annual convention in Hawaii. I don't think they'll ever go back there because it's a little too expensive, and they found their attendance dropped off. But it was a fun place to go once or twice. And it just so happened that the day during the convention, AGC released a white paper they had developed on addressing the risk of mold, because mold was the hot issue in the industry at the time. I used to teach a course at Georgia Tech Research Institute on some of the legal implications of mold. And, that had become the new asbestos or lead-based paint, or I guess silica's the rage now. But that was the hot issue in the industry. And AGC had published a paper saying, here's what you need to do to manage and minimize and try to keep your mold from being a problem in your projects. And I went up to the general counsel for AGC, who was the leader of the group that came up with this white paper, I'll call it. And I said, Mike, what you've done, you've just created Exhibit 1 in the trial the next time a contractor gets sued in a mold case, because they're going to lay that in front of them and say, you realize your own association says these are best practices for preventing mold from becoming a problem in a building. Did you do this? Did you do that? Did you do that? And his answer, I'll never forget, his answer was, we know that. We know that. But if there's a lawsuit, everybody's going to get sued. It's going to cost everybody a lot of money. The insurance is going to get involved. We're going to all spend millions of dollars, and then the case is going to settle. He said, we're better off to try to figure out some way to avoid having litigation as opposed to taking a defensive stance to try to protect us a little bit if we do get in litigation. I thought that was an excellent answer, and it's sort of the point I'm making here. Instead of hiding in your shell and not getting engaged, do it, but be smart about how you do it. And to illustrate this point, I think sort of the best way I can do that, is to talk about, is to kind of drill down and give you some specific examples of how things like CM at Risk and Design Assist and BIM, while having advantages and perhaps leading to greater efficiency and better projects, carries with it, at least potentially, some additional liability that you need to think about. And I want to focus on this topic I've kind of touched on already, which is design responsibility, because that's a biggie. And to make it more realistic, and people learn by, hopefully you learn from the mistakes of others. It also is always helpful to see how some of these legal principles apply in a real life setting. So it's not just some lawyer spouting off some theory he has. If you can see that this really has happened and there really are consequences. I'm going to talk about a case that hopefully none of your companies were involved in. Gilbane, who does have a significant presence here in Atlanta. I don't think there's anybody here today from Gilbane, but they were a party to this lawsuit. So was a company I'm not familiar with. In fact, I don't even know whether they pronounce their name Coghlan Electric or Coghlan Electric, but it's spelled Coghlin. The case out of Massachusetts, which may explain why I'm not familiar with them. But it's an interesting case to illustrate the point I'm trying to make here. And I will tell you that this one court decision sent shockwaves through the CM community. And I'm still running into people that hadn't heard of it, and when you describe it to them, it's a real eye-opener. But for the bigger, more sophisticated CMs, this has been a hot topic that they've been talking about ever since the decision came out. The trial court decision came out in 2015. So getting a little age on it now, but we're still talking about things that happened within the last few years. What happened in this case is, and I'll keep it kind of brief. First of all, I always kid about it. I talked earlier about how certain lawyers sort of know enough about construction law to be dangerous. If you've done a little bit of construction law and you call yourself a construction lawyer, one of the terms that you probably learned is something called the Spearin Doctrine. I expect most of you in this room have even heard the term Spearin Doctrine, even if you're not a lawyer. And basically what the Spearin Doctrine is a legal principle that is sort of unique to construction. At least that's where you usually see it arises in the context of a construction dispute or construction project. And it takes its name from a 1918 U.S. Supreme Court case, believe it or not. So it's a 100-year-old case that basically stands for the proposition that if an owner hires a design professional to design their project, they give you, the contractor, that design and they say, go build it. Even though the contract probably doesn't say this, and even though the owner may not realize this, the owner has impliedly warranted to you that if you use that design, it'll work. And if you follow the design and it doesn't work, and that ends up requiring a lot of extra work or rework or delays, extra costs, all the terrible things that happen on a typical construction project when something doesn't go right, that you have recourse, not against the architect, because you don't, under the old model, the design, bid, build traditional model, you didn't have a contract with the architect. Your contract was with the owner. So you have a claim against the owner, but for giving you a defective design. That is the Spearin Doctrine, that the owner impliedly warrants to the contractor that the design is not defective and will work. And if that warranty is breached, I don't think I've ever seen a contract that explicitly says, where the owner says to you, trust me, use this, and if there's a problem, I'll pay you for it. I mean, it may say it kind of a little bit, but this Spearin stands for the proposition of inhipsing. That's an implied obligation. Well, what happens to the Spearin Doctrine when you go design build? It goes out the window, because you, the design builder, are no longer relying on the owner for the design. You're the designer. What happens to the Spearin Doctrine in design assists? Well, I don't know. Kind of interesting. What does design assist mean in the context of this project? Exactly what is the subcontractor or the general contractor doing? In the Gilbane case, and since there's nobody from Gilbane, I'll use that to describe, use that title to describe, to refer to the case, and shouldn't hopefully offend anybody. Gilbane was not the designer. It was not a design build job. Gilbane was the CM at risk. The owner hired a design professional to design the project, gave Gilbane the design, told Gilbane to go hire the trade contractors to build the project. So if you drew it up like one of the neat org charts that I had when we were together before, you would have owner, design professional out here with their own line connected only to the owner. And then the owner has a contract with the CM to do the construction, and that was Gilbane. Well, the problem, though, was that if you read Gilbane's contract with the owner, their CM, it didn't say design build, it said CM contract. But if you read, not even the fine print, if you read the contract itself, what it said, and I was going to try to skip forward to that. Sorry, animated slides. Let me skip forward to this slide because it's kind of instructive. Gilbane's contract, as the construction manager, said that they were involved during the design phase. It said that they would review the design documents on a continuous basis, that they would conduct their own design review to make sure the design looked okay. It sounded like they were doing a little bit more than a constructability review. They were also reviewing the design to make sure it's just sort of a peer review, if you will, or a second set of eyes looking at the design. They weren't the designer of record. They didn't seal or stamp any of the drawings, but they were reviewing them, and they were reviewing them for clarity, consistency, maintainability, operability, and coordination among the trades. So they were involved in the design phase. They were reviewing the design. They weren't the designer of record. I think the case was even a little bit more, the ball moved a little more toward Gilbane getting an undesirable result because of some of the language in their proposal. I love to kid my general contractor and CM clients that CMs are notorious for putting things in their proposal that, that they will, where they promise the owner the star, the moon, the sun, that we can do all these wonderful things for you. And most construction managers would not want their proposal to become part of the contract. They don't want to have to, that's a little bit of salesmanship there, a little bit of puffing. Don't hold us to that. And it's sort of interesting, and I don't have an explanation for this. Somebody in the room may. But if you contrast that to subcontractors, who usually their proposal is just the opposite. Their proposal is, we don't promise you this, we don't promise you that, we exclude this, we exclude that. Most subs would love for their proposal to become part of the contract. So you've got this dichotomy there. But I think Gilbane had a proposal that painted how important they could be to the owner during the design phase. Well, you can kind of guess where this is going, that based on that contract and based on that proposal.
Was the proposal incorporated?
No, I don't think so. I don't think so. I don't think there's anything in the decision to indicate that, but yet the court did reference the proposal, as I recall. But technically, the proposal should have been irrelevant except to interpret ambiguous provisions in the contract, but they did talk about it. And I think you have to be a little careful there about you don't want to outkick your coverage in your proposal. But what happened now against that backdrop? The electrical trade contractor encountered what they, and everything in the case, talking about whether there is a legal basis to go forward with the case, not whether the evidence will support the case. But the allegation, at least, was that the electrical design was defective, that caused Coughlin Electric to spend a lot of time and money and be delayed. And so they filed a claim to recoup their additional cost against Gilbane, because that's who they had a contract with. Gilbane said, no problem. We're going to invite the owner to the party, and by making a third-party claim against the owner to say, if what this electrical contractor is saying is true, if the reason they spent all this extra money was because of the defective design that you gave us, that the electrical engineer working under your architect did, then you should be the one to foot the bill for that, not us. Well, the court disagreed. The court said, no, Gilbane, given all this that I've just described, you can't hide behind the Spearman doctrine. You were implicated in the design. You were part of the design process. So you don't have any recourse against the owner. If the electrical sub can prove their case that the design was defective, then you, Gilbane, have to pay for that, not the owner, which is a real eye-opener. You can kind of see how that. Now the case got appealed. On appeal, the result got narrowed a little bit, but even after appeal, it was a bad decision from the. In your materials, you've got sort of a summary of the Massachusetts Supreme Court's decision in the case, and there's some really strong language that we've quoted directly in these slides from that decision about what a CMAR, a CM. First time I heard somebody say CMAR, I didn't know what they were talking about. But some people use that to describe CM at risk. But a CMAR, what it means to be a CMAR if you are involved in the design process. So you can't just go by the title. Is the lesson learned there, and it was a painful and very expensive lesson for Gilbane. So,
Bill,
yes.
that particular case, such involvement in federal subcontractor have?
I don't know. That's a good question. And obviously that would be a defense Gilbane would raise to the extent they were involved. But I think that's a good question, and I don't remember that the decision gets into that so much. They focus more on Gilbane's role. But that's a real good question, and I could see that becoming key to how the case ultimately comes out as to whether there's a defense to their claim. I frankly know some folks at Gilbane. I was trying to keep up with what was going on with the case, although it's a little bit of a sensitive subject, and and I don't know what's happened with the case. I don't know whether they've since settled it or whether it's still going. But I'll see if I can find out. I'll let you know, because that would be interesting. So it goes back to this is a perfect example of before, we lawyers get criticized all the time for a lot of things. Many of them justified, maybe some not. But people, you've all heard the old joke of, I want to hire a one-armed lawyer, because every time I ask my lawyer a question, his answer is always, well, on the one hand this, and on the other hand that. And I never can get a straight answer from him. Well, there's reasons for that. Every time you change a fact, the answer to the question may change. And I could give you countless examples of that. Overton Curry, the Curry and Smith, Curry and Hancock was sort of half Southern minister. He's from Hattiesburg, Mississippi, and had gone to seminary school, and was sort of half Southern preacher and half construction lawyer. And Overton used to love to talk and teach through metaphors, or as we call them, parables. And one of his favorite parables was the parable of the dog, and it was, I wish I could remember it enough to go through the whole thing. I'm not sure we'd have time, but it went something like, you know, if you were walking down the street and you saw two dogs fighting, big dog and little dog, which one would you pull for? And everybody thought, I'd pull for the little dog. Well, what if I told you the reason they were fighting was the big dog was a mama dog, and the baby dog the smaller dog was trying to get the baby's food. Well, now I'm for the big dog. Well, what if and he could go back and forth with 20 rounds with every time you added a new fact, your answer changed. Well, that's sometimes how the law works too. But, you know, there is no simple answer. Any lawyer that gives you a simple answer doesn't understand the question. So anyway, there are exceptions to that, but that's the point. Design assist, I find, you know, that's almost like lean construction and some other buzzwords in the industry. It's hard to find two people that even have the same definition of what that is. But if you're getting involved in the design, then it could change your risks and responsibilities. And why do you do it then? Well, you know, there are a lot of studies that say, and this is probably intuitive to everybody in this room, that the earlier, you know, your ability to affect the cost of a project and the utility of a project is greater the earlier in the process you can get that input. And that's what this little simple chart is trying to show. That your ability to influence cost and time diminishes over time. So if I'm advising an owner, I say you really want to get your contractors. I mean, sometimes designers design to the lowest common denominator. They provide more electrical power than you really need because they don't really know what you really need. And they provide more capacity in various other areas, which is sometimes what leads to value engineering. Imagine if instead of doing value engineering on the back end, try to get it within budget, you got that input on the front end, so the thing was never over-designed in the first place. So that's the idea, and there's clearly benefit. BIM, wonderful tool. I could tell you war stories if we had more time about cases I had in the past where our firm earned a handsome fee and may have gotten a good result, but it came at a huge cost, that the case may have never existed if BIM had existed, because it was design conflicts that at least theoretically, if implemented properly, a computer model would have caught before you ever got out in the field and before you ever encountered the problem. I may or not have mentioned this last time. I had a case in South Carolina back about 20 years ago where my client was the owner, and they were building a pharmaceutical manufacturing and research facility in Florence, South Carolina. And they had the foresight. It was such a piping intensive job, and you had all these vessels and all these systems that cramming everything in the available space was going to be an issue. So they realized there would be some value to figuring out exactly how all that was going to be fit together, how it was all going to fit together, beyond what you could determine by doing two-dimensional drawings. So BIM didn't exist at the time. So they actually spent, believe it or not, $300,000 building a styrofoam model of the project before they constructed it. Well, the problem with that is styrofoam can bend, and if you have a clash in a styrofoam model, you can take an X-Acto knife and get rid of it. It's not quite as good as doing what we have now with three-dimensional digital modeling. But, so it's and you know, we had a case against our designer for design errors. We literally had, pipe fitters out on the job taking math classes on Saturday morning and try to figure out how to make everything fit together on that project. And we got what, at least at the time, when it was all said and done, we got what at the time at least was the largest award ever received in South Carolina, at least in the construction case, a $25 million award against our design professional. But it sure would have been nice for the client if they just would have gotten a design that worked. And I think if you had BIM or three-dimensional modeling at that time and used it properly, that case may have never existed. They would have had a much more successful project, yes. It's like an insurance question. As I recall, you know, it's funny, when you get into industrial projects, you see much higher limits than what you see in commercial. I've got another project right now where I know the design firm has got at least $20 million of coverage on their professional liability. I don't remember, theirs was at least $10 million. I suspect it did exceed their limits and that they had to come out of pocket. But it was, fortunately for us, it was Raytheon Engineers and Constructors, so they had enough money to pay it. But that is a good question because, as many of you know, when you're suing a design professional, if they don't have insurance, they may not be able to satisfy the judgment. So,
And in the commercial environment, we see commonly less than $5 million limits.
Yeah.
So there's rarely what we would consider sufficient limits. Although it's becoming more common, and if you have particular applications where you're looking at a particularly large project, they can buy limits dedicated to that project. So that's something to keep in mind. I wanted to ask, are you seeing any kind of particular claims patterns arising from the use of BIM? I mean, are there typical, you know, any kind of pattern to the disputes that you're seeing hit your office?
Great question. Not yet, at least. I'm glad to say, in fact, I have a friend, a construction lawyer in Philadelphia, that has a real interest in this area and has been monitoring court dockets for cases involving BIM, and he hadn't seen. I mean, he's seen a few where BIM is mentioned, but wasn't really the issue in the case. So I'm not saying it's the panacea and it's going to do away with litigation, but so far, I've not seen litigation arising out of BIM, but I don't think you can assume from that you never will.
How many folks in the room are working on projects or have recently worked on projects that utilize a BIM model? It's getting to be.
If we took that same vote 5 years from now, I bet all of you would raise your hand. It definitely is a way, and I'm not anti-BIM. I think it's a wonderful tool. I teach a legal and contractual segment of a BIM certification course. But let me make one more point about BIM, because I am about out of time, and this alone may be worth the price of admission since it was free, right?
And we gave them breakfast too.
And so you actually, so far you have, except for your value of your time, you're to the good today. Any of you ever seen something called a BIM transfer agreement? I had an electrical contractor client here in town, and this is your word of warning that will make you smarter. This one slide will make you smarter than most of your competitors. I have an electrical subcontractor client that I've represented for many years, and if they're doing a big project for somebody they've never worked for before, they'll send me the contract and ask me to review it. If they get something a little out of the ordinary, they'll send it to me to review. And, you know, I personally think that's, you know, good bang for your buck, because that doesn't cost very much. It doesn't cost near as much as litigating it on the back end. They were doing, I'll try not to mention the names, but they were doing a very high-profile project here in the Atlanta area for a major University Hospital. It wasn't any that Dave was associated with. And there was a BIM model on the project. And the subcontractor said, we were given this form and told that we have to sign it in order to work on the, this was after they're already on the job, they've already signed their subcontract. The design team, through the owner, sent this to the construction manager, sent this to all the subs, said we all got to sign this form. Well, the form was called a BIM transfer agreement. And these are just some of the provisions that were in that form. It said that the architect makes no representation regarding the accuracy, completeness, or permanence of e-documents or their merchantability. Okay, all right. It goes on to say, and this is the one that really hit me, owner/construction manager, and of course the construction manager is trying to flow this obligation down to all their subs, shall indemnify and hold harmless the architect for damages arising from use of e-documents. Now let's think about that. It doesn't say if you misuse them. If you're given electronic documents and told that's what you're supposed to use to build this job, and I've heard tales of projects in Texas, for example, where there is no printed drawings now. They're building projects from the model. If you're given electronic documents and told this is what you're supposed to use to do your job, to build the project, and oh, by the way, by using these documents, you agree that you will indemnify and hold us harmless from using them. Now what are you? Now you're the architect's professional liability insurance carrier, aren't you? I mean, if you're, so, I mean, I told my client, and I've got some other ones there too, I told my client, you'd be crazy to sign this form. He said, well, the construction manager signed it, and he said all the other subs had signed it. And I said, well, I said, okay, don't sign it. And this is one of those, I don't know the ending of the story. I don't know whether my client signed it or was too embarrassed to tell me that he signed it, or whether he bucked the system and got away with it. But look out for these. It's funny. This form I've seen used by a major structural engineer that many of you probably heard of. I've seen used by a large architectural firm that many of you have probably heard of. And just coincidentally, I met the general counsel for that architectural firm. She and I spoke on a program together. So I asked her about it. And she kind of was a little sheepish and said, yeah, I know. She said, that may be overreaching a little bit, but you know, if they're willing to sign it, we'd like to get that. Our insurance carrier wants us to get them to sign that because they're nervous about electronic documents. And the intent of this form is really, yeah, we probably paint with a little broader brush if we can get away with it, but what we're really concerned about is somebody misusing the model. And we want to be protected there, so we made it broader than that. But that's really what we're trying to guard against, is somebody adding something to the model, somebody misusing the model, and thereby creating a problem that we don't want to be responsible for. So look for those. I think I'm probably at the time I need to kind of wind this up. But on this whole subject of risk, and particularly design risk, I would urge you to assess your exposure, limit your exposure, and manage your exposure. I got at, and all of those are key. Part of managing it is to do it through insurance. I think you want to make sure if you are hiring an outside firm to do the design for you, You need to make sure, number one, they're good and they know what they're doing, but they're adequately insured. You want to have insurance of your own. It's kind of gotten where almost everybody in the industry, I don't know how y'all feel about this. I'd be curious to hear. Maybe you can share your views once I shut up here in a minute. But I think almost everybody in the industry now needs professional liability. I had a client, another electrical contractor client, a different one than the one I was just referring to, that it was like a light bulb going off, but they just realized within the past year that they're doing a lot of studies. They don't consider themselves a design builder, but on projects they're involved in, they're doing studies that arguably are design type work. And that he probably needs to be carrying professional. They hire somebody to do that. They hire an electrical engineer, but that they probably need to be carrying professional liability insurance. And I think you bet you do. And they are now doing that. So be careful who you contract with. Make sure they're adequately insured. Provide your insurance. But again, insurance is not a panacea either. It's one way of managing risk, but not the only way. And you need to do all those things. So with that, I'm going to